And you say you left a refrigerator,
Yes.
which you value at $2,500.
Yes, and that's what okay.
But you only gave him credit of $1,700 and some odd dollars for the refrigerator. How did you come to that evaluation?
So we agreed for the total amount of $44.66, and I would pay that at a prorated amount. That means I'm deducting the $168 a month off of his monthly rent. And by the time...
And the remainder is what you weren't able to work out through the rent.
And
Doesn't that sound reasonable to you? He gave you a rent deduction towards that, am I right?
Yes.
Did you do the math on the rent deduction to see if he paid you?
It was a little off, a couple $100, and then
that's enough.
we was willing to work for that. But after we get the walkout
I
thing,
have nothing further.
All right. So we're going to excuse the three of you while we deliberate in this matter.
This courtroom is now in recess. They dislike each other so much that they made what could have been a relatively straightforward transaction much more complicated than it needed to be. The countersuit, to me, I think is baseless. There's no evidence that the property was so uninhabitable that they had to move. The refrigerator, as I understood the testimony and evidence, they've already been given a credit for that refrigerator. So I think that's off the table.
I think he gave him off $168 for 10 months,
Correct.
which comes out to about $1,700. So credit him with that.
I would dismiss the countersuit. Rent is clearly owed. I am going to abide by the late fees in the contract. I'd give them that. I started by questioning the $150 charge on the LED light. I think it's fair.
You saw evidence of that, right?
I saw evidence.
That light itself, okay.
Yep. And then other damages, the other things they were charging them for.
Yeah, they touch-up paint on the walls, $850
That's
for that.
I mean, what do you guys think about that?
I think
to
it's
me seems
preposterous.
excessive.
It is.
No.
And you know
wear and
why
tear.
it's costing that much money? Because the walls haven't been painted. So when they went over it with the white paint, it was in different contrast.
Right.
I'd give them the touch-up on the stucco because it was damaged.
$400?
I'd give them that.
Look, did you see the stucco? It's like there's no way they're going to match that up. It's just old. And how do you know he did it? Did you see
That's
him?
right. I agree with you on the stucco. Nothing on the stucco.
Right.
It's the exterior.
I mean, the way I see it, they reminded me of two boxers before a prize fight. The way they were posturing themselves and talking to each other, So I think it clouded the whole case because it was simply a question of mathematics. But I agree with Judge Acker as to how she evaluated the deductions.
I think the plaintiff was a little condescending throughout.
Mano
to the
y mano,
defendant,
it was like there was
And I think that the defendant felt that and got his back up in a way.
So the defendant owes $150 for the light plus a month and a half of rent and late fees.
$807.
It looks like the plaintiffs would only be entitled to $957.
That's correct. That's correct.
Yeah.
The $807
and of course, the defendant,
late fees and the $150.
The defendant admitted that he owed him.
That he owes
so
them.
it's not a problem.
So $950.
All right.
$950. I think
We're
that's
unanimous?
fair. Yeah.
This court is again in session. Thank you, Officer Montejano. We've deliberated and we've reached a unanimous verdict. You gentlemen are a piece of work. I mean, the case was so strange because it seems like it could have gone much better than it obviously did. It somehow devolved into, I'm going to use my DOJ access, and you guys became a hot mess. So it's a good thing that you're out of there. Mr. Smith, we reviewed your countersuit and we're dismissing it in its entirety because you're suing him for moving expenses, some of that being predicated on what you claim were the uninhabitable conditions of the premises, but there was just no evidence of that. So with respect to the refrigerator, the evidence supports the plaintiff's position that you and your partner were already given credit for the refrigerator. So we're dismissing your countersuit, but we do wish you the best. So good luck to you and good luck to your fiance. Mr. Antoine, you've prevailed to some extent, but not on everything. There were some damages about which we had concerns. We're not giving you $850 to touch up the wall paint, nor are we compensating you for the exterior stucco damage. Don't know who did that. We're not going to just assume that everything that was wrong with the property was his fault. Some things we're awarding you money for replacing the light, and we're also going to give you the rest of the back rent and late fees that he owes you. So the judgment in this case will be in your favor for $957. Everybody go off, get married, stay out of each other's way. Good luck.